Join one of Virginia's oldest and most experienced personal injury law firms as we explore how the law does and doesn't work, the art of leadership, and the power of community. Now, here are your hosts, Peter Burnett and Jonathan Slater.
This morning, we are so fortunate to have John Flannery with us. And if you watch any amount of MSNBC TV, you will regularly see John with Ari Melber at 6 o'clock most nights, offering his expertise based on having been a prosecutor in the Southern District of New York's U.S. Attorney's Office and having been counsel to 3 different legislative committees in the House of Representatives over the course of his career. We are blessed to have him as a capable and outstanding defense attorney and civil litigant here in Loudoun County for many, many years. And he has agreed to come talk to us today, primarily, I think, about the process of impeachment, how it was intended, how it's playing out, and what we can expect to see to the extent our looking glasses have any accuracy. And I would, with that, ask John if he would just lay out for us a little bit what the impeachment process was originally intended to be, and then we can start parsing how it has played out in this particular case in 2019 and 20. John?
Well, here it is, 2020. That's really something. Peter, thank you so much for inviting me. I've spent a lot of time talking about this issue, so if you have any questions as I rumble along, please just interrupt and ask me a question. Anyhow, I'm used to being interrupted. If you watched Ari Melber and myself, the best part is when we improvise, I think, both substantively and sometimes we give the audience a chance to rest from the severity of the discussion about our constitutional crisis. Going back to the beginning, the Articles of Confederation weren't strong enough for the nation. And so Hamilton and Madison and others thought they had to have a special convention. And some thought it was just to revise the Articles, but instead it was the Constitution that we now have. And one of the areas that they focused on was, what do we do if we have a King George III here, a monarch? How do we have a chief executive if we have a tripartite, 3 departments of government? And the answer was that we have to have some form of impeachment. And the question was, would a majority vote be enough? And they said no. And so what they did is they tried to evoke earlier instruments of containing executives, impeachment processes. And there were some models that they could draw upon in the original colonies for this and after the Articles of Confederation. And so they sought to have high crimes and misdemeanors or bribery and other things. And their big concern was, should they have several persons as a chief executive? And when they decided on one, they were, given the context, historical context, particularly afraid that they would have a monarch or despot. And it was very interesting that Benjamin Franklin, when at the end of the convention, who was guarded lest he say something that compromised this new constitution of Borning, they asked him what he thought of the document that had been created. And he said, you have a republic if you can keep it. And one of the greatest fears from the beginning, therefore, was whether or not we could have a government that was safe from a monarch, a despot. And the checks and balances that were contemplated gave to Congress the power of the purse, gave them impeachment, gave them censorship. And at the beginning, you may recall, the Senate and these bodies that existed was going to choose the chief executive. So there were these problems from the beginning.
Well, and to be clear, and I think it wasn't until 1913 that United States senators were elected.
Correct.
They were appointed by state legislatures to their positions in the Senate. I don't know if the term changed. I think it did, but that's part of that process, is it not?
Yes, that's correct. And, we said at the outset that we're going to perfect this union. And so the amendments and the things we've done since that gave the vote to blacks, that gave the votes to women, that made it a more democratic process in our republic are all perfections of an original contemplation, which was the Constitution. And we've had several efforts at this. One was after the Civil War, when Johnson was impeached. And the question, a difficult one that I think even Lincoln would have had trouble getting through, was how do we now deal with the fact that instead of fractional persons that represent representation in the Congress, we now have a full person, a person who is a slave, who's free and can vote. And those states that swore allegiance to the government were then allowed to participate in that Congress. And that included Confederate generals. And the radicals, the Republican radicals in Congress, sort of feared what they created by the reunion of the Union, if you will. And Johnson was in a very difficult position because he was trying to deal with it. And the radical Republicans were very excited about the fact that they had the Secretary of War giving them information about what Johnson was doing. And so he fired him, and they had an act that prohibited him from doing that, and that was part of his impeachment. And ultimately, he was not removed from office, as we know. And the act that was what fomented this impeachment was later declared unconstitutional. Now, going forward, the next one we had was Nixon, and we didn't really have one. We passed articles of impeachment in the House, but there was never a vote on the floor of the House supporting them. But they involved such things as abuse of power and obstruction of the Congress. And the third article of impeachment, so named, was that. And I think the precedential significance of that was that it was a bipartisan vote for these articles of impeachment. So it gives them some gloss that shows there's a standard of law that justifies going forward as a lawful body rather than the partisan impulses that Madison spoke against.
And let me stop you there for a second, because I think this whole issue of partisanship has become a big deal, and it's impossible to claim any observance of what's been going on in our country over the last 15 or 20 years to not recognize that there's been a very significant diminution of bipartisanship, if you will.
I agree.
That it's been party loyalty, party loyalty, party loyalty. Now, you arrived while you were in the Southern District during the very first parts or the very end of Nixon's time in office, but you were soon enough down in the United States Congress working. What was your experience during your career there in terms of seeing bipartisanship at work compared to what you see today?
Well, I see two things. One is that in the Southern District of New York, I went to that office in part because the evidence of its independence was signified by the U.S. Attorney Whitney North Seymour. In fact, during the Nixon administration, caused the indictment of his own boss, the Attorney General, John Mitchell. The office was considered very independent in that way. Whitney North Seymour was a Republican. And then the appointments that I had in the Senate, both the Judiciary Committee and the Labor Committee, one after the other, were by chairpersons who were Republican. And this is after, in 1980, I had been active in Ted Kennedy's presidential campaign, his primary campaign in New York. So when I appeared at the first day as approved by Chairman Orrin Hatch to be special counsel to the Senate Labor Committee, like every overachiever, I came to the meeting early. And the only senator there at the time was Ted Kennedy. And Ted said, "John, what are you doing here?" And I said, "I'm special counsel to the Senate Labor Committee." He said, "No, you're not." So he thought I was kidding. I said, "Yes, I am." And as the ranking member on the committee, he would be the logical person to appoint a person who was a Democrat. And he said, "Well, I didn't appoint you." And I said, "Orrin did," referring to Orrin Hatch. So he got close to me and he says, "Does he know about us?" And I said, "Yes." And he sort of hit his forehead. So I witnessed in those years, this is in the 80s, Ted Kennedy and Orrin Hatch working closely on a number of issues. And at the same time, being in opposition on other issues. It may not have been a golden age, but it represented a period when legislators governed and didn't only campaign. And the period when Clinton came on the scene, and Republicans as well, we invented the never-ending campaign, which is part of the problem with partisanship. That said, when I came over to the House in 96, the intensity of partisanship was stronger between the 80s and 96 and after that. And I ended up working on the Clinton impeachment for the Democrats as a special counsel. And the appointments then were much more partisan. Now, maybe I was older, and so I had a more identifiable Democratic cast. Anyhow, and I had run for Congress in between. The voters decided I should have made a trial lawyer instead. So the 95,000 votes I got in the Northern Virginia region weren't enough to get a seat in Congress. And the voters, I decided, since may have done me a favor, because I belong to an honest profession as a lawyer, like you. So,
hear, hear.
So the the impeachment of Clinton, really like the impeachment of Nixon, was still bipartisan. There was cooperation. There were some Democrats who were very critical of Clinton, and the conversation did lead to rules in the Senate, which is where we find ourselves now with the Trump impeachment. That is to say, every senator voted approval for rules to conduct the trial of Mr. Clinton. And presiding Justice Rehnquist had, in fact, written a book called The Grand Inquest just before it, which focused on the Johnson impeachment and on the impeachment of Justice Chase. So he had studied the matter. They limited the number of witnesses at that proceeding. Now, what America doesn't appreciate, seemingly, despite all the time we've been talking about this, is what the House does is, like a grand jury, comes up with charges and obtains evidence, and the Jefferson Manual provides that any committee could come up with charges and report it to the full House and go forward. We had a more formal procedure in Trump, and we had a very formal procedure in the connection with Clinton, both of which took about the same time. The Clinton impeachment, the Starr report came up in September. In November, we had hearings, I can tell you because I sat in them. And then we had the vote in December of 1998, and I was on the floor of the House, just a few feet from Livingston, demanding the impeachment or resignation of Mr. Clinton. And I was sitting next to Congresswoman Maxine Waters. And when Livingston said, Clinton should resign, she said, you should resign. And I was sitting right next to her. And then a few minutes later, he did resign. He resigned as the Speaker because of an embarrassment of his own ethics involving ladies. And at that point, Maxine turned to me and she said, did he do that because we said it? I said, I'm sorry, Maxine, but I didn't say anything. I'm just here as a
good
counsel.
Politician that she is.
Yeah. So I said, I think he planned it beforehand, but and she laughed.
Well, and let me stop you there for a second.
Yeah.
So you're describing, if I'm understanding you correctly, a continuing trend towards or away from bipartisanship, or from Nixon to Clinton and forward, and that hasn't stopped. And everybody seems to want an impeachment proceeding to be bipartisan, and of course that makes a certain amount of sense, so that it's not based on some political philosophy, but instead based on misconduct purely, and folks can recognize all facts, and bribery is not a political event, it's a criminal event.
Correct.
But I don't think, when you break it down, that anybody would say, I would hope not, that because there's a high level of bipartisanship in Congress, that there should be no impeachment. That if only one party wants to enforce the impeachment's edicts in the Constitution and the other one doesn't for political or other reasons, that therefore we should suspend the process of impeachment. It seems to me that we're stuck a little bit with a less than perfect impeachment process that is not bipartisan particularly. We don't know where it's going to go when the actual trial, whatever that turns out to be, takes place. But to say that because only one party voted for impeachment, and it happened to be the majority party, and of course the only way to get them through, the articles through, it shouldn't be done, it should be nullified, strikes me as a more severe criticism of the process than having one that is not bipartisan, but at least having it.
Well, I think, Peter, you have the benefit of years of litigation, and so you and I both think in terms of the law. It's a necessary element in the Constitution as the standards by which we should act, and that impulsive or, I just want it kind of notions are not legal, not standards, and that's not how things should be done. The the problem here, and
We call that loyalty to the rule of law. Is that a fair way of describing it? And facts.
Now, being a registered but not a voting Roman Catholic, I was always impressed by the exchange between Sir Thomas More, his son-in-law, Roper. And the exchange was, did More have to swear an oath to the king as the head of the new church, as opposed to the Roman Catholic Church, where Henry VIII had been the defensor fidei, the defender of the faith? And More said, well, silence is acquiescence, so why do I have to do anything? And Roper said, well, you should just do it. What is the law anyhow? And I would tear down all the laws in the land to get at the devil. And More said the equivalent of, I'm sure you would, and how would you stand in the wind that blows? Because these are all men's laws, not God's laws, and how could we stand? That's where we are now. We have a president, we keep saying, who is not above the law, but he exults in being above the law, ignoring the law. And like we've learned from our practice, that if we don't enforce the law, bring it to an issue when it's ripe, and have courts and juries and so forth decide these things, then we have a lawless society. And that's where we are.
Let me step back from the needing the assertion that we have a president who is breaking the law.
Right.
That, in some respects, is the whole purpose of the impeachment trial. My difficulty with the process is that you can't make the determination of whether or not somebody is breaking the law in a reliable fashion that people can have confidence in, unless you put the very best evidence out there in an open, adversarial way, such that everybody can see it for exactly what it is. Now, are they going to interpret it somewhat differently? Probably. But that said, the notion that, it was double hearsay and we didn't hear from any of the people who were actually involved in the crime, if indeed it was a crime, and then at the same time, and therefore we can't give it any credence, and then in the same breath saying, but I don't want to hear from those people who were up close and personal and saw the whole thing. Those two things don't go together for me. It's very troubling to me that we are not seeing folks who are complaining about the quality or the first-hand nature of the evidence in the United States Congress as part of the indictment, if you will, process, the impeachment article development, resisting getting that very good evidence that they say they didn't get in the House.
Well, the answer is that we've had more than sufficient evidence. And though the standard is not beyond a reasonable doubt, because this is not a criminal proceeding, what we have is the President of the United States basically saying in a transcript of his conversation, when the President of Ukraine, Zelensky, says, I need javelins, and he says, yeah, but I have one favor, though, which is an investigation of his principal rival as perceived by polls in the introduction of Biden into the race. So he wants to investigate him when there is no existing investigation. And the quid pro quo, as they said, which can be legitimate, but the shakedown, the extortion, the bribery is that I'm holding $391 million of public funds that you need to defend yourself against Russia in an act of war. But, until there's an investigation of Biden and his son, I don't really see any reason to give you that. And those funds were withheld until a whistleblower spoke. We not only have the readout from the president, we have the president making public statements, indeed asking China to do the same thing. And then we have Mulvaney saying, we do that all the time, get over it. And we have Rudy Giuliani. I can't say that he's a reliable reporter, but he does repeatedly make admissions against interest. The question of hearsay that America has been misled about by Republicans who write laws that supposedly outline what these things mean, they're misled to believe that an admission, a confession, though hearsay, is unreliable, and exactly the opposite is true. We use admissions all the time. The second thing that's
to be clear, in a court of law, an admission, even though it may have been an out-of-court statement, is an exception to the hearsay rule. Exactly. It is considered information and something that a jury can consider.
It's admissible hearsay. And so are statements of co-conspirators in furtherance of an illegal agreement considered exceptions to the hearsay rule that are admitted as evidence. And so the argument, unlike bipartisan past experience, in which people will at least try to determine and agree upon the facts and agree upon the law, here we have a situation in which there's no other way to put it. Republicans are more concerned as a caucus, in no way previously, in my experience, so rampantly terrified of having a primary and losing their position. And to cite Mel Brooks in Blazing Saddles, they want to keep their phony baloney jobs more than they want to serve their oath of office to protect us from a lawless, unconstitutional chief of state.
And don't you need one more element for that to be so? And I'm not saying it's that element's not there, but that they are confident that if they buck the president, that he will see to it that they are primaried in their next election.
Yes. Well, not only do we have that deterrent, we also have a president who has literally made contributions to 4 of the senators in close races so that they would be opposed to impeachment. We have a senator who had a conversation with the president about what was going on in Ukraine, so he's a witness. We have the leader of the Senate, Mr. McConnell, who's basically said he's going to coordinate this entire thing with the President of the United States. We have a vice president who would sit in consideration of any majority vote in a trial in the Senate, who is himself involved in the very offense because he participated in the dealings with Zelensky, the head of Ukraine.
And that raises the question for me, John, about the role of the Chief Justice. I would like to think that the Chief Justice's role in presiding over the impeachment, and I would hope that it extends perhaps to some pretrial matters, including the oath and other things, but that he is more than a figurehead in 4 gold stripes on each arm.
Like Rehnquist.
Right. That he would be able to rule on substantive matters. And of course, the operative word there is rule, because apparently the Senate can vote in their own rules, which may be to vote out the ability of the Chief Justice to really pass on anything substantive other than call your next witness.
Well, yes, I think you've summarized it exactly correctly. And my view is that while we have the House appoints managers and they become the quote prosecutors, and obviously Representative Schiff, who's shown himself as a former prosecutor to be a voice of reason, and I presume that he would be among any managers. I think, though, the attitude is not just to think of this as a prosecutor, but I think you have to approach it as a defense counsel who's on notice that the tribunal, the Senate, is not a fair tribunal. And the judge, who is the Chief Justice of the United States, is in a very difficult position, because what I would do as a manager would be to immediately put him on notice with motions. That is to say, I think certain of these people should be recused. And not being and not based on expressing an opinion about the outcome or the guilt or innocence of Trump, but being paid, accepting money from the president, being a witness, saying the things that McConnell has said. Now, the judge very well might deny those motions, but I think the only way to approach the Senate is as a soiled body. Well,
he might say, I'm not authorized by the Constitution to even hear that motion.
Well, I think he is.
Which concerns me.
Well, I think he is. And what you would cite as the model is both Johnson and Clinton. The rules that were written for the Johnson impeachment, the post-Civil War impeachment, involved rules that were revised in the 70s and have been revised during the Clinton proceeding. And Jefferson wrote a manual. I guess the guy always had time to write something. He wrote a manual that dealt with this, and it's been updated. And in that manual are the rules that were used during the Clinton impeachment. And there was quite a very complicated set of pretrial motions, just like you say. Now, you're absolutely right that the judge could say, he could rule, we have to have witnesses. And then they would have, the Senate might, under McConnell, who fears, I think, any legitimate witness appearing there, compromising his ability to control the Senate in the next election. And so he doesn't want any witnesses, which will be an impossible position for him to sustain, I think, politically, because we already have 2 senators who are concerned about it. And I think they're staging themselves to come out. And it only takes 4 senators probably to control the procedure. We're never going to get a fair procedure in the Senate. That's not going to happen.
And how many times do you hear a defense lawyer on a drunk driving charge or any other state court matter in the criminal world, and even some in the civil world, we'll always, we lawyers, litigators, talk about, oh, this judge doesn't like this, or this judge has always leaned this way or leaned that way. And that's part and parcel of our justice system, that in some way it has to deal with, let's just call them leanings, as opposed to outright bias. But there are limits to that, right?
Yeah, I think so. And I'm arbitrarily somewhat saying that because a senator said either Trump should remain or Trump should leave, that's not the basis, I think.
They're letting him sit.
We'd let him sit, yes.
Right.
But when you've received money for the specific proposition, when you have made arrangements, and that's why I think somebody should say, okay, I want to see if you have a memorandum of understanding with the White House. I want to know what you did when you're coordinating. Is it just saying, here's the room, here's how things might operate, or is it much more than that? Are you promising them votes and things like that? Are you going to move to dismiss it on a majority vote rather than have a trial? And in that trial, is it going to be fair if the outcome is predetermined because you're whipping your people, telling them they'll be primaried or they won't get money or things like that? In other words, is this a corrupt trial with some appearances of a trial, but not, in fact, due process, fundamental fairness?
And that creates some blurry lines. Different people will see the line being drawn in different places. But I'm interested what your opinion is on a statement, whether it comes from the leader or anybody else, saying, I'm not impartial. I already know how I'm going to vote.
Well, then I think you can't take the oath.
Can that person be challenged?
Yes, I believe so. Now, here's the thing. In our lawless age, which is how I characterize this entire proceeding, you and I would be treated very differently if we did something than this elite, this political elite, who have associated with Trump as their benefactor, provided in this S&M relationship they do what he wants.
Okay.
And if we have a proceeding in which people, say, had a sealed vote, for instance, I don't know if that would be good or bad. In the Clinton administration, they had a sealed discussion of the articles of impeachment, and then they went into public session to have the vote. So that would be one thing. The question is, what does Justice Roberts do in this very difficult situation when given one of these very difficult motions? Rehnquist, I think, was more forgiving of the prosecution in that case than I wonder if Roberts would be.
And do you mean more deferential to them?
More deferential, I thought, yes. Right. And I think it's an important error to say this is a political proceeding other than in the sense that these are elected officials. I think that the standard that they should be adopting, and I think what the oath means, is that you're going to follow the facts and you're going to follow the discussion of the law, and based on that, you're going to make a decision which may be against the bias you came in with, may be against your partisan preferences, and in those cases, if they're not removed, maybe against the funds that you accepted for your campaign to be reelected, having promised that you were against impeachment.
You're listening to Law and Community, a podcast from Burnett and Williams Personal Injury Lawyers.
So I think that's a very difficult set of tasks for the chief judge. And it's hard to believe, but it is possible, given what we've seen, that then the Senate, the Republican caucus, will vote as one to overrule the justice. What do you have then? How many times can you overrule the justice who's sitting there and call it a fair proceeding? So that's why I think it's important that we move to the point by mid-January, early February, of having the trial and accepting the fact that it's not going to be fair, and we have to be inside the belly of the beast. We have to be within the well of the Senate, and we have to have filed complicated motions by lawyers who are good enough to do that and to argue them to the chief judge. And if the chief judge doesn't allow the argument, denies the motions without reviewing them, then he is legitimately subject to attack. I was in Florida once, and I had some judge say to me that I was jerking his chain by asserting a constitutional right of my client in a criminal case. And I thought, what am I going to do? And they had a process to remove the judge. So I thought, well, the hell with it. I'll make that motion. And I did, and I removed him. I had 2 more judges just as bad as he. And I made those motions. I went through them. And finally, the 4th judge I got, he and I had a conversation in the first meeting, and for the first time, it was a difference in the law instead of a bias. We only have 1 chief judge. There's no machinery in our Constitution for what happens if he's biased. And so this is the weakness of our whole process. The constitutional crisis here, aside from the positions about how bad this is and is this a high crime and misdemeanor, is that the law doesn't seem to be working.
Well, and because it's based, this whole thing, it's what I, over the course of 40 plus years of doing this, like you, have become pretty discouraged with the oath itself. That I think when I started practicing law, and certainly in the 30, 40 years before that, when someone put their hand on the Bible and took the oath, they literally thought they were going to burn in hell if they didn't tell the truth.
Right.
I think that oath has become considerably more casual and therefore unreliable, and our whole system is based on it. Our system is based on folks having an enormous respect for the truth, and the commitment to the rule of law is seemingly more tenuous, or it's more in elastic, competition. Certainly. Elastic, yep, and it seems to be competing with other so-called important interests.
Well, you may remember,
political and otherwise.
Yeah, you probably focused, as a trial lawyer would, on Lewandowski, who appeared before the House Judiciary Committee and said, "I can lie. I can lie if I want. Why should I tell you the truth? You're the enemy." And that's basically what he said. And it seems to be a rampant invocation among these people who are associated with Trump and the Republicans. I sat through, in part because I was going to comment on it, the entire judiciary session, which was, I think it was 14 hours. So I sat on a set with a light on me and a monitor watching the thing, and from time to time would comment on it. And there was a lot of repetition, but what I saw was several things happening, particularly among Collins and No Jacket Jordan, who were the 2 leaders of the Republicans on the House Judiciary Committee. And that's the committee that I served during the Clinton impeachment.
This is Mr. Collins.
Yeah, Mr. Collins, and yes, that's right. Not the senator, the House, right? It's right. The House, right. And
I think it's Douglas Collins, if I'm not mistaken.
Yes, that's correct. And it was interesting. They speak in an auctioneer's voice, and they speak very quickly, and it was sort of an army of phrases wandering across the vast landscape in search of an idea. And they would just sort of say things like sound was enough sometimes. I'm not saying they made no arguments, but a lot of it was kind of that. And it became clear that
relatable sound bites.
Relatable sound bites. But for instance, go read the transcript of the readout, which was the conversation that Trump had with Zelensky. And if you read it, and I guess they counted on people not reading it or not understanding it, or taking their interpretation, you would say, whoa, is that what he was doing? He's talking specifically about Biden. He's talking specifically about these things. And on the very day he's doing it, we had a Department of Defense witness who said the Ukrainian embassy said, "Where's our money?" that same day. And that same day, we've also learned in the last week or so, he was using the OMB in a way that hadn't been used before to stop the money right then. And so we wonder why Zelensky, who is literally at war with a neighbor, Russia, that some might say is Trump's handler, Putin, and we're not helping Ukraine, despite the fact that both houses of Congress supported taking care of Ukraine. So this is a crisis unlike anything involving Nixon or Clinton, certainly. Maybe it's comparable to Johnson, but even Johnson was more like an ideological struggle of how do we reorganize America after a civil war. This is a unilateral deference to foreign leaders at the expense of our policy, the safety of our allies in NATO, and the Ukraine peoples.
And no doubt, as alleged, probably as serious as any impeachment offense that this country has seen.
True.
But to go back to your earlier comment about how we need to move forward with the impeachment sometime in January, whether it be mid, early, or late,
Right.
But to me, I would say, what choice does anybody have to walk away from an impeachment proceeding? And when I say impeachment proceeding, it's really a conviction proceeding, is it not? The
Yes.
impeachment has already happened.
The impeachment are the charges.
That's
and they're
the
pending.
indictment. He's been
Right.
indicted. And so now what we're talking about is a trial as to guilt or innocence, which means removal or not removal.
Right.
And that's got to be the real trial. But
Well,
would it not be more damaging in the long run to our society and our confidence in our form of government for us to say, oh, now that we can't have the witnesses we want, forget it, we're not going to do it?
Yes, that would be wrong for a number of reasons.
I think it would be wrong.
Yeah. Well, I thought that's what you were saying, being
Right.
a little bit of devil's advocate. Well, first of all, as we're sitting here, what is this, the third day of the new year?
I think that's right.
Congress had 1 day of session left after the actual impeachment vote for anything to happen. And then there was the Christmas, New Year's break, if you will, or High Holy Days break, Hanukkah and so forth. And Congress, as we sit here, won't be in session until next week. And Monday's usually not a real day in terms of the consent calendars and stuff like that happen. So by Tuesday, Congress will be back in session. So we have lost so far 1 day, and a second day is going to happen. Now, there will never be sufficient assurances by McConnell or the Senate that it's going to be a fair trial. My view is that one of two things happen. They either have a fair trial, or we're talking to a jury larger than those 100 bodies. It's the entire nation. We've made the case, in my opinion, in the House, that we have a crisis, we have a lawless impulse in the nation. We're led by a person who doesn't know better and goes from one place to another in a reckless and unlawful fashion. So is the Senate so in combination that that's our point? And I believe it is. We're going to be trying them, the Senate, to the nation. And they are either going to do well or badly, and they have 23 senators, I believe, on the Republican caucus side that are up for election. 4 or 5 of them are in danger. So I have no problem with the fact that if the Senate doesn't have a fair trial, and in my opinion, even though I'm not a juror, the evidence is so overwhelming, it's a slam dunk case. In real life, we would have a plea. In real life, we would do something like what happened with Nixon. That is, if everybody was fair and just and went by the rule of law and the Constitution. But I don't believe this Senate can do that, and McConnell has proven it. We have data points in the past as how he's ignored constitutional mandates involving the High Court of the land, holding back a nomination to the Supreme Court for like a year.
Let me stop you there and ask you for a political prediction, is what I think it is. And that is, let's assume that somehow evidence gets in front of the Senate such that there are 51 or more votes in favor of removal, obviously not meeting the standard
Correct.
Provided by the Constitution of a supermajority. But nonetheless, it's inescapable that a majority of the Senate believe that the President of the United States should be removed. What impact does that have on the President?
If even
and
one
the country, for that matter.
If even one Republican crosses over, it will be an enormous event damaging the White House. If there's a trial and that is the result, two things happen. The Senate's reputation will be irreparably damaged itself, because it will be hard to believe, if there's any trial at all by that time, that they could vote to find him not guilty. And if there are public statements on the floor...
When you say any trial at all, let me define that a little bit. That means having the prime witnesses,
any witnesses
who in your view, would make it, if they tell the truth, would make it abundantly clear that this was what's been alleged at the House level and proven to a certain extent, would be even more clear as a result of these witnesses testifying.
Well, you see, I think the commentary in which people try to be fair when the evidence is overwhelming have done a disservice to the nation. The evidence is overwhelming in a way that often doesn't happen when you indict a person in a normal criminal case. And this is not a criminal case. We could argue whether it's a preponderance of evidence or clear and convincing, and how the Senate was slice and dice that standard, which is more rigorous thinking than it it appears so far they're ready to embrace. But all of that said, I think that what we have here is when you charge somebody with an offense, civil or criminal, by the time you go to trial, you often get more evidence. And so there's no prohibition, it seems to me, to be offering more evidence. I feel it's more of a stunt to be asking for certain people that the White House has withheld in the past. It's almost like if I try a criminal case and people assert the Fifth Amendment, I try the case without them testifying, and maybe they get prosecuted and are tried separately. But we have literally a crime syndicate in the West Wing that's extended through the cabinet. People who tell that they're going to abide by an oath by swearing their hand before the Chief Justice. Are they going to be prosecuted for perjury? By what? This Justice Department? By Barr? No. With a president who could pardon them? No. And that's our American dilemma. That's why we are a lawless nation in the context of our national government as compared to people that get a speeding ticket or get into an argument with somebody and assault someone and are held to a strict rule of law. These people are almost lawless. And at the most critical juncture in our society, how we run our government from the chief executive. And all three departments are confounded in a way that reminds you of authoritarian governments. We are appointing judges willy-nilly who have never tried cases to the bench so that they can sustain an ideology which will be announced, I assume, by Trump as time goes on. We have legislators, elected Republicans, who are in lockstep with that president. And then, of course, we have Trump, who's somewhat unpredictable, who governs by tweeting, which has become the new way. And it's not so much the mechanism as it is the instantaneous nature of decisions that are so critical to the life and well-being of the nation.
But for that to perpetuate itself, for it to have any life, it requires, I think, the cooperation of voters at some level. And I've been saying here in recent years that we're forgetting or abdicating our responsibilities in not recognizing that democracy is a participatory sport. It is not a spectator sport. And our grandparents and great-grandparents would go to big packed theaters of fellow citizens to listen to essentially political speeches. Brian and Darrow and others talking about the way things should be and the way we should be governed and et cetera. That was stimulating dinner table conversation in many, many homes. And I think those things we carry around in our pockets and those screens that we look at of one sort or another have caused us to drift away from a lot of that. And the discipline to do research and find out what the facts are and to be so willing, which how many times have we heard that all the things that you've said and that you accept as being truths get dismissed as fake news.
Right.
And,
True.
And how does this society overcome that so that we get back to what you and I are very comfortable with, and John is chasing rule of law truth.
Right.
Finding the truth with mechanisms that have safeguards against fake stuff interfering and poisoning it.
You and I are children of the 60s, and we have, across the span of our lifetime, seen the most dramatic changes come from the people, not from our elected officials. Nixon, Iraq, each of these events came from the people, and our elected officials were slow to decide what to do. I think the same thing happened with this impeachment thrust. When finally, in his underawing performance, Mueller came before the House Judiciary Committee and said what Barr said was misleading. He didn't say it that way. And the upcoming election is still at danger. We immediately saw a shift in the public, despite his understated performance and the fact that he didn't come there with banners and so forth, which the press criticized him for failing to produce. But that the people heard it. Now, Jefferson said a couple of things. He had a long belief in the people making the right decisions. The disinformation has always existed, but never with the mechanisms that now exist that target individuals, find out what they care about, and mislead them. And Jefferson also said, a nation that expects to be ignorant and free expects what never was and never will be. That's the tension in America. Now, do we have data points suggesting the public's getting it? Yes. We've had a number of elections which I think have changed the political order because sometimes it was just the decency of the campaign. We saw it statewide in Virginia. We saw it again in a recent election. And so what I think we have is the suspense of history. I think the proof of a divinity is that for an alert mind in a lifetime, you can never be bored. Doesn't mean you get to be happy. And life is full of crises. And the question is how we deal with this one. And Seneca was a firm believer that great challenges burnish character and that are opportunities and gifts to those people who lead. We have some leaders. They've been inconsistent, and politicians will always break your heart. But I'm hoping that in this crisis, a number of people will decide this is it, and that their offices are not as important as serving the nation, so that this young experiment gets a chance to succeed as a republic rather than as a dictatorship. And I'm very concerned that as we talk, we have the winds of war in the Middle East caused by a president who is under an impeachment challenge, and what that will mean and who will come forward with what strength to say that this is more of an argument for impeachment than to withdraw. We have the cowards in a bipartisan way spread across the nation. This is a time for political courage. It's no accident that JFK's book, Profiles in Courage, is a brief book. And if there was a time that we need to add a chapter, it's now.
I couldn't agree more, and beautifully stated. I think a piece of evidence of there being some limit to what the public will tolerate is there being polls out there that suggest that about 70% of the public want to see witnesses in the Senate. And I think that speaks to how ingrained our judicial system's rules of civil and criminal procedure have become. Our idea of a trial is not an accusatory mechanism as there are in other countries, but is one of an adversarial process where both sides get to hear the close-up evidence and cross-examine it, and out of all of that comes some level of truth to which hopefully we're all committed. But that said, I'm going to use a term that we heard repeatedly watching all these hearings in Congress, and that is that we should suspend and get you to come back in about another, what would you say, John, about 2 months? I'll bet you John can add a whole lot to this discussion with the evidence that's going to come forward. Some evidence, I don't know what it's going to be, over the course of this impeachment process.
I'd enjoy doing that. That would be fun. Yeah.
Great, John.
Yes, and I want to thank you for this opportunity. What I found over the years is that these kinds of dialogues sort of give voice to what other people are thinking, and they may not necessarily agree. But what happens is it engenders a conversation, a constructive engagement, like I saw in my early days on the Senate side when people governed and tried to do what best they could to serve the country. And the challenge of our time is, will politicians come forward and be statesmen and serve the nation rather than themselves?
That's a big deal. And let's just cross our fingers that we're at the zenith of the bad part of that, and we're going to move back in the other direction. I'm sure it's a sine curve, but let's start climbing the mountain of it from here, because I think we're in a trough at the moment. Right. But we'll get you back, John, and thank you so much.
Thank you. It was a pleasure. Nice being with you.
You too.
Thank you for listening to Law and Community, a podcast from Burnett and Williams. If you have any questions or wish to learn more, please leave us a message at our website, www.burnettwilliams.com. Also, please don't forget to subscribe to the show on whatever platform you're listening to. Don't forget to follow our Facebook page at www.facebook.com/BurnettWilliams and give us a call at 703-777-1650 for any questions you have. Hope you enjoyed the episode. Until next time, take care.